Article 90. Prescription of crimes. Crimes punishable by death, reclusion perpetua or reclusion temporal shall prescribe in 20 years. Crimes punishable by other afflictive penalties shall prescribe in 15 years. Those punishable by a correctional penalty shall prescribe in 10 years, with the exception of those punishable by arresto maior, which shall prescribe in 5 years. The crime of libel or other similar offenses shall prescribe in 2 years. The offenses of oral defamation and slander by deed shall prescribe in 6 months. Light offenses prescribe in 2 months. When the penalty fixed by law is a compound one, the highest penalty shall be made the basis of the application of the rules contained in the first, second and third paragraphs of this article. Article 91. Computation of prescription of offenses. The period of prescription shall commence to run from the day on which the crime is discovered by the offended party, the authorities, or their agents, and shall be interrupted by the filing of the complaint or information, and shall commence to run again when such proceedings terminate without the accused being convicted or acquitted, or are unjustifiably stopped for any reason not imputable to him. The term of prescription shall not run when the offender is absent from the Philippine archipelago. Article 92. When and how penalties prescribe. The penalties imposed by final sentence prescribe as follows. 1. Death and reclusion perpetua, in 20 years. 2. Other afflictive penalties, in 15 years. 3. Correctional penalties, in 10 years, with the exception of the penalty of arresto maior, which prescribes in 5 years. 4. Light penalties, in 1 year. Article 93. Computation of the prescription of penalties. The period of prescription of penalties shall commence to run from the date when the culprit should evade the service of his sentence, and it shall be interrupted if the defendant should give himself up, be captured, should go to some foreign country with which this government has no extradition treaty, or should commit another crime before the expiration of the period of prescription. Section 2. Partial extinction of criminal liability. Article 94. Partial extinction of criminal liability. Criminal liability is extinguished partially. 1. By conditional pardon. 2. By commutation of the sentence, and 3. For good conduct allowances which the culprit may earn while he is serving his sentence. Article 95. Obligation incurred by person granted conditional pardon. Any person who has been granted conditional pardon shall incur the obligation of complying strictly with the conditions imposed therein, otherwise, his non-compliance with any of the conditions specified shall result in the revocation of the pardon, and the provisions of Article 159 shall be applied to him. Article 96. Effect of commutation of sentence. The commutation of the original sentence for another of a different length and nature shall have the legal effect of substituting the latter in the place of the former. Article 97. Allowance for good conduct. The good conduct of any prisoner in any penal institution shall entitle him to the following deductions from the period of his sentence. 1. During the first 2 years of his imprisonment, he shall be allowed a deduction of 5 days for each month of good behavior. 2. During the 3rd to the 5th year, inclusive, of his imprisonment, he shall be allowed a deduction of 8 days for each month of good behavior. 3. During the following years until the 10th year, inclusive, of his imprisonment, he shall be allowed a deduction of 10 days for each month of good behavior, and 4. During the 11th and successive years of his imprisonment, he shall be allowed a deduction of 15 days for each month of good behavior. Article 98. Special time allowance for loyalty. A deduction of 1/5 of the period of his sentence shall be granted to any prisoner who, having evaded the service of his sentence under the circumstances mentioned in Article 158 of this Code, gives himself up to the authorities within 48 hours following the issuance of a proclamation announcing the passing away of the calamity or catastrophe referred to in said article. Article 99. Who grants time allowances? Whenever lawfully justified, the Director of Prisons shall grant allowances for good conduct. Such allowances, once granted, shall not be revoked. Title 5. Civil Liability. Chapter 1. Persons civilly liable for felonies. Article 100. Civil liability of person guilty of felony. Every person criminally liable for a felony is also civilly liable. Article 101. Rules regarding civil liability in certain cases. The exemption from criminal liability established in subdivisions 1, 2, 3, 5, and 6 of Article 12 and in subdivision 4 of Article 11 of this code does not include exemption from civil liability, which shall be enforced subject to the following rules. First, in cases of subdivisions 1, 2, and 3 of Article 12, the civil liability for acts committed by an imbecile or insane person, and by a person under 9 years of age, or by one over 9 but under 15 years of age, who has acted without discernment, shall devolve upon those having such person under their legal authority or control, unless it appears that there was no fault or negligence on their part. Should there be no person having such insane, imbecile or minor under his authority, legal guardianship, or control, or if such person be insolvent, said insane, imbecile, or minor shall respond with their own property, excepting property exempt from execution, in accordance with the civil law. Second, in cases falling within subdivision 4 of Article 11, the persons for whose benefit the harm has been prevented shall be civilly liable in proportion to the benefit which they may have received. The courts shall determine, in their sound discretion, the proportionate amount for which each one shall be liable. When the respective shares cannot be equitably determined, even approximately, or when the liability also attaches to the government, or to the majority of the inhabitants of the town, and, in all events, whenever the damage has been caused with the consent of the authorities or their agents, indemnification shall be made in the manner prescribed by special laws or regulations. Third, in cases falling within subdivisions 5 and 6 of Article 12, the persons using violence or causing the fears shall be primarily liable, and secondarily, or, if there be no such persons, those doing the act shall be liable, saving always to the latter that part of their property exempt from execution. Article 102. Subsidiary civil liability of innkeepers, tavern-keepers and proprietors of establishments. In default of the persons criminally liable, innkeepers, tavern-keepers, and any other persons or corporations shall be civilly liable for crimes committed in their establishments, in all cases where a violation of municipal ordinances or some general or special police regulation shall have been committed by them or their employees. Innkeepers are also subsidiarily liable for the restitution of goods taken by robbery or theft within their houses from guests lodging therein, or for the payment of the value thereof, provided that such guests shall have notified in advance the innkeeper himself, or the person representing him, of the deposit of such goods within the inn, and shall furthermore have followed the directions which such innkeeper or his representative may have given them with respect to the care of and vigilance over such goods. No liability shall attach in case of robbery with violence against or intimidation of persons unless committed by the innkeeper's employees. Article 103. Subsidiary civil liability of other persons. The subsidiary liability established in the next preceding article shall also apply to employers, teachers, persons, and corporations engaged in any kind of industry for felonies committed by their servants, pupils, workmen, apprentices, or employees in the discharge of their duties. Chapter 2. What civil liability includes. Article 104. What is included in civil liability? The civil liability established in Articles 100, 101, 102, and 103 of this code includes 1. Restitution. 2. Reparation of the damage caused. 3. Indemnification for consequential damages. Article 105. Restitution, how made. The restitution of the thing itself must be made whenever possible, with allowance for any deterioration or diminution of value as determined by the court. The thing itself shall be restored, even though it be found in the possession of a third person who has acquired it by lawful means, saving to the latter his action against the proper person, who may be liable to him. This provision is not applicable in cases in which the thing has been acquired by the third person in the manner and under the requirements which, by law, bar an action for its recovery. Article 106. Reparation, how made. The court shall determine the amount of damage, taking into consideration the price of the thing, whenever possible, and its special sentimental value to the injured party, and reparation shall be made accordingly. Article 107. Indemnification, what is included. Indemnification for consequential damages shall include not only those caused the injured party, but also those suffered by his family or by a third person by reason of the crime. Article 108. Obligation to make restoration, reparation for damages, or indemnification for consequential damages and action to demand the same, upon whom it devolves. The obligation to make restoration or reparation for damages and indemnification for consequential damages devolves upon the heirs of the person liable. The action to demand restoration, reparation, and indemnification likewise descends to the heirs of the person injured. Article 109. Share of each person civilly liable. If there are two or more persons civilly liable for a felony, the courts shall determine the amount for which each must respond. Article 110. Several and subsidiary liability of principals, accomplices, and accessories of a felony, preference in payment. Notwithstanding the provisions of the next preceding article, the principals, accomplices, and accessories, each within their respective class, shall be liable severally, in solidum, among themselves for their quotas, and subsidiarily for those of the other persons liable. The subsidiary liability shall be enforced, first against the property of the principals, next, against that of the accomplices, and, lastly, against that of the accessories. Whenever the liability in solidum or the subsidiary liability has been enforced, the person by whom payment has been made shall have a right of action against the others for the amount of their respective shares. Article 111. Obligation to make restitution in certain cases. Any person who has participated gratuitously in the proceeds of a felony shall be bound to make restitution in an amount equivalent to the extent of such participation. Chapter 3. Extinction and survival of civil liability. Article 112. Extinction of civil liability. Civil liability established in Articles 100, 101, 102, and 103 of this code shall be extinguished in the same manner as other obligations, in accordance with the provisions of the civil law. Article 113. Obligation to satisfy civil liability. Except in case of extinction of his civil liability as provided in the next preceding article, the offender shall continue to be obliged to satisfy the civil liability resulting from the crime committed by him, notwithstanding the fact that he has served his sentence consisting of deprivation of liberty or other rights, or has not been required to serve the same by reason of amnesty, pardon, commutation of sentence, or any other reason. Book 2. Crimes and Penalties. Title 1. Crimes against National Security and the Law of Nations. Chapter 1. Crimes against National Security. Section 1. Treason and Espionage. Article 114. Treason. Any person who, owing allegiance to the United States or the government of the Philippine Islands, not even a foreigner, levies war against them or adheres to their enemies, giving them aid or comfort within the Philippine Islands or elsewhere, shall be punished by reclusion perpetua to death and shall pay a fine not to exceed P20,000 pesos. No person shall be convicted of treason unless on the testimony of two witnesses at least to the same overt act or on confession of the accused in open court. Article 115. Conspiracy and proposal to commit treason, penalty. The conspiracy or proposal to commit the crime of treason shall be punished respectively, by prison mayor and a fine not exceeding P10,000 pesos, and prison correccional and a fine not exceeding P5,000 pesos. Article 116. Misprision of treason. Every person owing allegiance to the United States or the government of the Philippine Islands, without being a foreigner, and having knowledge of any conspiracy against them, who conceals or does not disclose and make known the same, as soon as possible to the governor or fiscal of the province, or the mayor or fiscal of the city in which he resides, as the case may be, shall be punished as an accessory to the crime of treason. Article 117. Espionage. The penalty of prison correccional shall be inflicted upon any person who 1. Without authority therefore, enter a warship, fort or naval or military establishment or reservation to obtain any information, plans, photographs or other data of a confidential nature relative to the defense of the Philippine archipelago, or 2. Being in possession, by reason of the public office he holds, of the articles, data or information referred to in the preceding paragraph, discloses their contents to a representative of a foreign nation. The penalty next higher in degree shall be imposed if the offender be a public officer or employee. Section 2. Provoking war and disloyalty in case of war. Article 118. Inciting to war or giving motives for reprisals. The penalty of reclusion temporal shall be imposed upon any public officer or employee, and that of prison mayor upon any private individual, who, by unlawful or unauthorized acts provokes or gives occasion for a war involving or liable to involve the Philippine Islands or exposes Filipino citizens to reprisals on their persons or property. Article 119. Violation of neutrality. The penalty of prison correccional shall be inflicted upon anyone who, on the occasion of a war in which the government is not involved, violates any regulation issued by competent authority for the purpose of enforcing neutrality. Article 120. Correspondence with hostile country. Any person, who in time of war, shall have correspondence with an enemy country or territory occupied by enemy troops shall be punished. 1. By prison correccional, if the correspondence has been prohibited by the government. 2. By prison mayor, if such correspondence be carried on in ciphers or conventional signs, and 3. By reclusion temporal, if notice or information be given thereby which might be useful to the enemy. If the offender intended to aid the enemy by giving such notice or information, he shall suffer the penalty of reclusion temporal to death. Article 121. Flight to enemy's country. The penalty of arresto mayor shall be inflicted upon any person who, owing allegiance to the government, attempts to flee or go to an enemy country when prohibited by competent authority. Section 3. Piracy and mutiny on the high seas. Article 122. Piracy in general and mutiny on the high seas. The penalty of reclusion perpetua shall be inflicted upon any person who, on the high seas, shall attack or seize a vessel or, not being a member of its complement nor a passenger, shall seize the whole or part of the cargo of said vessel, its equipment or personal belongings of its complement or passengers. The same penalty shall be inflicted in case of mutiny on the high seas. Article 123. Qualified piracy. The penalty of reclusion temporal to death shall be imposed upon those who commit any of the crimes referred to in the preceding article, under any of the following circumstances. 1. Whenever they have seized a vessel by boarding or firing upon the same. 2. Whenever the pirates have abandoned their victims without means of saving themselves, or 3. Whenever the crime is accompanied by murder, homicide, physical injuries, or rape. Title II. Crimes against the fundamental laws of the state. Chapter 1. Arbitrary detention or expulsion, violation of dwelling, prohibition, interruption, and dissolution of peaceful meetings and crimes against religious worship. Section 1. Arbitrary detention and expulsion. Article 124. Arbitrary detention. Any public officer or employee who, without legal grounds, detains a person, shall suffer 1. The penalty of arresto mayor in its maximum period to prisión correccional in its minimum period, if the detention has not exceeded 3 days. 2. The penalty of prisión correccional in its medium and maximum periods, if the detention has continued more than 3 but not more than 15 days. 3. The penalty of prisión mayor, if the detention has continued for more than 15 days but not more than 6 months, and 4. That of reclusion temporal, if the detention shall have exceeded 6 months. The commission of a crime, or violent insanity or any other ailment requiring the compulsory confinement of the patient in a hospital, shall be considered legal grounds for the detention of any person. Article 125. Delay in the delivery of detained persons to the proper judicial authorities. The penalties provided in the next preceding article shall be imposed upon the public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities within the period of 1 hour. Article 126. Delaying release. The penalties provided for in Article 124 shall be imposed upon any public officer or employee who delays for the period of time specified therein the performance of any judicial or executive order for the release of a prisoner or detention prisoner, or unduly delays the service of the notice of such order to said prisoner or the proceedings upon any petition for the liberation of such person. Article 127. Expulsion. The penalty of prisión correccional shall be imposed upon any public officer or employee who, not being thereunto authorized by law, shall expel any person from the Philippine Islands or shall compel such person to change his residence. Section 2. Violation of domicile. Article 128. Violation of domicile. The penalty of prisión correccional in its minimum period shall be imposed upon any public officer or employee who, not being authorized by judicial order, shall enter any dwelling against the will of the owner thereof, search papers or other effects found therein without the previous consent of such owner, or, having surreptitiously entered said dwelling, and being required to leave the premises, shall refuse to do so. If the offense be committed in the nighttime, or if any papers or effects not constituting evidence of a crime be not returned immediately after the search made by the offender, the penalty shall be prisión correccional in its medium and maximum periods. Article 129. Search warrants maliciously obtained and abuse in the service of those legally obtained. In addition to the liability attaching to the offender for the commission of any other offense, the penalty of arresto mayor in its maximum period to prisión correccional in its minimum period and a fine not exceeding 1,000 pesos shall be imposed upon any public officer or employee who shall procure a search warrant without just cause, or, having legally procured the same, shall exceed his authority or use unnecessary severity in executing the same. Article 130. Searching domicile without witnesses. The penalty of arresto maior in its medium and maximum periods shall be imposed upon a public officer or employee who, in cases where a search is proper, shall search the domicile, papers or other belongings of any person, in the absence of the latter, any member of his family, or in their default, without the presence of two witnesses residing in the same locality. Section 3. Prohibition, interruption, and dissolution of peaceful meetings. Article 131. Prohibition, interruption, and dissolution of peaceful meetings. The penalty of prisión correccional in its minimum period shall be imposed upon any public officer or employee who, without legal ground, shall prohibit or interrupt the holding of a peaceful meeting, or shall dissolve the same. The same penalty shall be imposed upon a public officer or employee who shall hinder any person from joining any lawful association or from attending any of its meetings. The same penalty shall be imposed upon any public officer or employee who shall prohibit or hinder any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuses or redress of grievances. Section 4. Crimes against religious worship. Article 132. Interruption of religious worship. The penalty of prisión correccional in its minimum period shall be imposed upon any public officer or employee who shall prevent or disturb the ceremonies or manifestations of any religion. If the crime shall have been committed with violence or threats, the penalty shall be prisión correccional in its medium and maximum periods. Article 133. Offending the religious feelings. The penalty of arresto maior in its maximum period to prisión correccional in its minimum period shall be imposed upon anyone who, in a place devoted to religious worship or during the celebration of any religious ceremony, shall perform acts notoriously offensive to the feelings of the faithful. Title 3. Crimes against public order. Chapter 1. Rebellion, sedition, and disloyalty. Article 134. Rebellion or insurrection. How committed? The crime of rebellion or insurrection is committed by rising publicly and taking arms against the government for the purpose of removing from the allegiance to said government or its laws, the territory of the Philippine Islands or any part thereof of any body of land, naval or other armed forces, or of depriving the chief executive or the legislature, wholly or partially, of any of their powers or prerogatives. Article 135. Penalty for rebellion or insurrection. Any person who promotes, maintains, or heads a rebellion or insurrection, or who, while holding any public office or employment takes part therein, engaging in war against the forces of the government, destroying property or committing serious violence, exacting contributions or diverting public funds from the lawful purpose for which they have been appropriated, shall suffer the penalty of prisión maior and a fine not to exceed 20,000 pesos. Any person merely participating or executing the commands of others in a rebellion shall suffer the penalty of prisión maior in its minimum period. When the rebellion or insurrection shall be under the command of unknown leaders, any person who in fact directed the others, spoke for them, signed receipts and other documents issued in their name, as performed similar acts, on behalf of the rebels shall be deemed the leader of such rebellion. Article 136. Conspiracy and proposal to commit rebellion or insurrection. The conspiracy and proposal to commit rebellion or insurrection shall be punished, respectively, by prisión correccional in its maximum period and a fine which shall not exceed 5,000 pesos, and by prisión correccional in its medium period and a fine not exceeding 2,000 pesos. Article 137. Disloyalty of public officers or employees. The penalty of prisión correccional in its minimum period shall be imposed upon public officers or employees who have failed to resist a rebellion by all the means in their power, or shall continue to discharge the duties of their offices under the control of the rebels, or shall accept appointment to office under them. Article 138. Inciting to rebellion or insurrection. The penalty of prison mayor in its minimum period shall be imposed upon any person who, without taking arms or being in open hostility against the government, shall incite others to the execution of any of the acts specified in Article 134 of this Code, by means of speeches, proclamations, writings, emblems, banners, or other representations tending to the same end. Article 139. Sedition, how committed. The crime of sedition is committed by persons who rise publicly and tumultuously in order to attain by force any of the following objects. 1. To prevent the promulgation or execution of any law or the holding of any popular election. 2. To prevent the insular government, or any provincial or municipal government or any public officer thereof from freely exercising its or his functions, or prevent the execution of any administrative order. 3. To inflict any act of hate or revenge upon the person or property of any public officer or employee. 4. To commit, for any political or social end, any act of hate or revenge against private persons or any social class, and 5. To despoil, for any political or social end, any person, municipality or province, or the insular government or the government of the United States, of all its property or any part thereof. Article 140. Penalty for sedition. The leader of a sedition shall suffer the penalty of prison mayor in its minimum period and a fine not exceeding 10,000 pesos. Other persons participating therein shall suffer the penalty of prisión correccional in its maximum period and a fine not exceeding 5,000 pesos. Article 141. Conspiracy to commit sedition. Persons conspiring to commit the crime of sedition shall be punished by prisión correccional in its medium period and a fine not exceeding 2,000 pesos. Article 142. Inciting to sedition. The penalty of prisión correccional in its maximum period and a fine not exceeding 2,000 pesos shall be imposed upon any person who, without taking any direct part in the crime of sedition, should incite others to the accomplishment of any of the acts which constitute sedition, by means of speeches, proclamations, writings, emblems, cartoons, banners, or other representations tending to the same end. Chapter 2. Crimes against popular representation. Section 1. Crimes against legislative bodies and similar bodies. Article 143. Acts tending to prevent the meeting of the legislature and similar bodies. The penalty of prisión correccional or a fine ranging from 200 to 2,000 pesos, or both, shall be imposed upon any person who by force or fraud prevents the meeting of either of the House of the Legislature or of any provincial board or municipal council. Article 144. Disturbance of proceedings. The penalty of arresto mayor or a fine ranging from 200 to 1,000 pesos shall be imposed upon any person who disturbs the meetings of either of the House of the Legislature or of any provincial board or city or municipal council, or in the presence of any such bodies should behave in such manner as to interrupt its proceedings or to impair the respect due to it. Section 2. Violation of parliamentary immunity. Article 145. Violation of parliamentary immunity. The penalty of prison mayor shall be imposed upon any person who shall use force, intimidation, threats, or fraud to prevent any member of either House of the Legislature from attending the meetings thereof, from expressing his opinions or casting his vote, and the penalty of prisión correccional shall be imposed upon any public officer or employee who shall, while the legislature is in session, knowingly arrest or search any member thereof, except in case such member has committed a crime punishable under this code by a penalty higher than prison mayor. Chapter 3. Illegal Assemblies and Associations. Article 146. Illegal assemblies. The penalty of prisión correccional in its minimum and medium periods and a fine not exceeding 1,000 pesos shall be imposed upon the organizers or leaders of any meeting attended by armed persons for the purpose of committing any of the crimes punishable under this code, or of any meeting in which the audience is incited to the commission of the crime of treason, rebellion or insurrection, sedition, or assault upon a person in authority or his agents. Persons merely present at such meeting shall suffer the penalty of arresto mayor. Article 147. Illegal associations. The penalty of prisión correccional in its minimum and medium periods and a fine not exceeding 1,000 pesos shall be imposed upon the founders, directors, and presidents of associations totally or partially organized for the purpose of committing any of the crimes punishable under this code or for some purpose contrary to public morals. Mere members of said associations shall suffer the penalty of arresto mayor. Chapter 4. Assault upon, and resistance and disobedience to persons in authority and their agents. Article 148. Direct assaults. Any person or persons who, without a public uprising, shall employ force or intimidation for the attainment of any of the purposes enumerated in defining the crimes of rebellion and sedition, or shall attack, employ force or seriously intimidate or resist any person in authority or any of his agents, while engaged in the performance of official duties, or on occasion of such performance, shall suffer the penalty of prisión correccional in its medium and maximum periods and a fine not exceeding 1,000 pesos. When the assault is committed with a weapon or when the offender is a public officer or employee, or when the offender lays hands upon a person in authority. If none of these circumstances be present, the penalty of prisión correccional in its minimum period and a fine not exceeding 500 pesos shall be imposed. Article 149. Indirect assaults. The penalty of prisión correccional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon any person who shall make use of force or intimidation upon any person coming to the aid of the authorities or their agents on occasion of the commission of any of the crimes defined in the next preceding article. Article 150. Disobedience to summons issued by a legislative body or committee, and refusal to testify before same. The penalty of arresto mayor or a fine ranging from 200 to 1,000 pesos, or both such fine and imprisonment, shall be imposed upon any person who, having been duly summoned to attend as a witness before either house of the legislature, or before any committee thereof, refuses, without legal excuse, to obey such summons, or being present before any such body or committee, refuses to be sworn or placed under affirmation or to answer any legal inquiry or to produce any books, papers, documents, or records in his possession, when required by them to do so in the exercise of their functions. Article 151. Resistance and disobedience to a person in authority or the agents of such person. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon any person who, not being included in the provisions of the preceding articles, shall resist or seriously disobey any person in authority, or the agents of such person, while engaged in the performance of official duties. When the disobedience to an agent of a person in authority is not of a serious nature, the penalty of arresto menor or a fine ranging from 10 to 100 pesos shall be imposed upon the offender. Article 152. Persons in authority, who shall be deemed as such. In applying the provisions of the preceding and other articles of this code, any person directly vested with jurisdiction, whether as an individual or as a member of some court or governmental corporation, board or commission, shall be deemed a person in authority. Chapter 5. Public Disorders. Article 153. Tumults and other disturbances of public orders, tumultuous disturbance or interruption liable to cause disturbance. The penalty of arresto mayor in its medium period to prisión correccional in its minimum period and a fine not exceeding 1,000 pesos shall be imposed upon any person who shall cause any serious disturbance in a public place, office, or establishment, or shall interrupt or disturb public performances, functions or gatherings, or peaceful meetings, if the act is not included in the provisions of Articles 131 and 132. The penalty next higher in degree shall be imposed upon persons causing any disturbance or interruption of a tumultuous character. The disturbance or interruption shall be deemed to be tumultuous if caused by more than 3 persons who are armed or provided with means of violence. The penalty of arresto mayor shall be imposed upon any person who in any meeting, association, or public place, shall make any outcry tending to incite rebellion or sedition or in such place shall display placards or emblems which provoke a disturbance of the public order. The penalty of arresto menor and a fine not to exceed 200 pesos shall be imposed upon those persons who in violation of the provisions contained in the last clause of Article 85 shall bury with pomp the body of a person who has been legally executed. Article 154. Unlawful use of means of publication. The penalty of arresto mayor or a fine ranging from 200 to 1,000 pesos shall be imposed upon 1. Any person who by means of printing, lithography, or any other means of publication, shall maliciously publish as news any false news which may endanger the public order or cause damage to the interest or credit of the state. 2. Any person who by the same means shall encourage disobedience to the law or to the constituted authorities or praise, justify or extol any act punished by law. 3. Any person who shall maliciously publish any official resolution or document without proper authority, or before they have been published officially, or 4. Any person who shall print or publish books, pamphlets, periodicals, or leaflets which do not bear the real printer's name. Article 155. Alarms and scandals. The penalty of arresto menor or fine not exceeding 200 pesos shall be